The role of a trustee in bankruptcy may vary from case to case, depending on how complex it is. But essentially, a bankruptcy trustee is responsible for administering the bankruptcy in accordance with the Bankruptcy Act. The trustee will oversee the bankruptcy administration for the full term of the bankruptcy, which is usually 3 years. They will notify the creditors and determine the value of the bankrupt's property and other assets. Some assets are protected property, but if not, or if it is commercial to sell it, it is the trustee's job to do so. The other primary role of a trustee, in addition to administering the bankruptcy, is to act as an intermediary between the bankrupt and the creditors. The trustee must provide information to the creditors as they reasonably request it and ensure that any available funds are distributed evenly amongst the creditors in accordance with the order set out in the Bankruptcy Act. And finally, the bankruptcy trustee must ensure that the bankrupt person adheres to their obligations as set out under the Bankruptcy Act. If the bankrupt fails to comply with their obligations, the trustee can object to their discharge. The bankruptcy term is usually 3 years. However, it can be extended up to 8 years if the bankrupt fails to comply with requests from the trustee in bankruptcy.